What was he accused of specifically?
He was accused of, I think this is correct, basically false advertising. That
wasn't accused of fraud?
That may have been a part of it.
You don't recall if he was formally accused of fraud?
No, I don't think he was. I think he was just accused for basically advertising without a license.
Were you called as a defense or a prosecution witness?
I guess I was called as a defense.
Oh, as a defense witness.
I was there with him.
I see. So he was accused of false advertising. You say. I'd like to know exactly, but let's assume it's that. And the false advertising was for advertising that he was a licensed contractor using your license number.
Actually, he was the lady that I think took him to court. He was accused of advertising as being a licensed contractor and not being one. And he was actually advertising, which I have no earthly idea why, under my son's company, Innovation Properties. But he was using my license number.
Okay, so he was accused formally in court of advertising using your license number. And your contention is that he did that. He shouldn't have done that. You never hinted to him that he could do that, and it was totally fraud on his part to do that.
I probably helped send him to jail. I mean,
okay.
I couldn't.
But you were called as a defense witness.
I was just there, and they asked me to speak.
Here's the thing. You say in your affidavit of June 3rd, 2008, and this is exactly what it says, and you signed it, and a notary notarized it. And I don't think you're disputing that you signed it. For the last 2 years, he agreed to pay my renewal fee if in return, on occasion, he could pull permits with my license number. Now, you signed this affidavit saying that you did that. Now, you have subsequently testified here that you didn't want to do that unless he and I had some kind of agreement. Those are some now, you understand now, if you didn't then, that even if you and I agreed on you and he agreed on something, that he couldn't use your license number to pull a permit, correct? Do you understand that that's not legal?
Would you repeat that, please?
Do you understand that it is not legal, even if you've got an agreement with someone, that he can go use your license number to pull a permit?
Yes, I understand that.
Okay, you understand
I would not let him do that.
All right. Well,
and
let me just say this. Let me ask you this: do you not I'm asking the questions. Do you not consider sitting down with your brother and making this kind of agreement as a conspiracy to commit a crime?
No, sir, not at all.
Okay, that's fine.
We had that conversation.
I wanted a yes or no question answer, and I've got it. Do you not think that conversation you had with your brother, when he agreed to pay your renewal fees in exchange for using your license number, do you not believe that gave him tacit approval to go ahead and use your license number when he wanted to? He never paid your license fees?
No, sir. He never paid my license fee, and the confusion here is the investigator asked me because my brother had told him. I had this conversation. My brother's talking to the investigator. He says to the investigator that he had talked to the investigator about
to hearsay.
About paying the fees.
A moment, please.
I'm going to object to hearsay for anything that's stated by parties that are not present. They're not here. I don't know who he's speaking of, but that person is not here. I can't cross the person and whether or not he made the statements, and I can't cross-examine his brother and whatever statements he might have made this investigator.
When you were called to the defense of your brother, did you admit on the witness stand at that case under oath that you had anything about this conversation about the permit?
That particular thing was never a
Okay.
part of it.
All right, that's all I've got for now.
He never paid your fees, and he never pulled a permit.
Never paid my fees, and he has never pulled a permit.
Currently using your license to build projects?
Yes, sir.
Mr. Carlton, in Exhibit 2, this letter that you signed,
Yes.
it says, "We have never talked, seen, and then we have not entered in any type of contract." Who are we?
Me and my brother. My brother was doing business as A1 Home Improvements. I knew nothing about it until some of this started coming to light.
The we, you're speaking about you and your brother. You and your brother have never seen or talked to this Tammy person, and you and your brother have never entered any type of contract agreement with Tammy.
I'm sorry. I have never entered with any type of agreement with Tammy. I didn't even know Tammy until this complaint came about.
Stated we. I'm just curious who.
Yeah, that's
we.
what I mean. We, I guess, just me. I've never entered into any kind of contract with Tammy Longoria. And that's one of the reasons why I think I wrote this letter was to the statement about Carlton Homes Incorporated accepts no liability and responsibility for this unfounded complaint against us. And then I never heard anything else about it. I sent this to the board and never heard anything else about it. So, and I told Gary to take care of it, and I just thought it went away.
Johnny, you've answered this, but one more time. Gary never gave you any money whatsoever for a license or anything. Is that
Gary
correct?
has never given me any money.
And you were not aware that Gary was pulling permits or whatever. You're contending that when Gary did something, he never pulled a permit. He
Gary
just
has
was
never
showing
pulled a
that.
permit under my license. He's used my license number, and he's made these people think that he was a legitimate contractor because of the name Carlton.
When you said he used your license number on internet advertising for himself, is that right?
Yes.
And what did you do when you saw that the first time?
I went ballistic. I made him take it off.
You made him take it off. Did you notify the Board of Licensing Contractors that your license was being used fraudulently?
No.
Did you notify the district attorney?
I didn't notify anybody.
You didn't notify anybody. You just went to your brother and said, "Quit doing that."
Yes.
Did he tell you that did he tell you directly that he had used your license for any other job, for any jobs at all?
No.
He just put your license number on his website just for the fun of it?
Give him a job.
To get him a job.
You know, I mean, and that's why I guess he's gotten his punishment.
Do you not suspect that this conversation you had with him, suggesting to him that he could do that, was the reason he did that?
I think that if he and I would have followed through on that, what I thought was a private conversation, had we followed through on there, absolutely yes. But nothing ever occurred.
Well, something did occur because he used your license number, didn't he?
Something occurred in his own mind. But he knew, based on the conversation that we had, that he was completely not allowed to use my license because I had to come over from Knoxville and handle one of his complaints.
That's the question. Thank you.
You're saying now that this statement that you made with your brother and this agreement that you had with your brother was done in 2003 rather
2003, 2004. I remember when he came out to the manufacturing plant that I was at, and he apologized, and he said, you know, and if we can do something, can we do some business? Because I think he had some jobs that he had secured or something.
What do you mean then by the phrase, for the last 2 years he agreed to pay my renewal fee? why would you sign that in 2008, a phrase like that?
Because the investigator asked me, did I in fact ever have this conversation with my brother?
But you wrote for the last 2 years, he agreed, and you signed this in 2008. I'm confused.
Well, and this
by
is
your
something
chronology.
that I wrote down in my own handwriting, and it's like
Is
I
this
was
your-
even confused about the issue at the
Is
time.
this your handwriting then? Gary Carlton is my brother to the end of this affidavit?
Yes.
Okay. All right.
Any additional questions, board members? Doesn't look like there's any additional questions for you, sir. You may return to
All right.
your chair.
Call Carolyn as a rebuttal witness, please. Ms. Lazenby. The 8 previous complaints that you identified earlier, were they copies of those complaints sent to Mr. Carlton?
In 2004, it was sent to Car Development, P.O. Box 1548, Brentwood, Tennessee 37024, and this is when his license was in the name of Car Development.
That license number was associated with that, and that's the address you have on record for that license number at that time.
Yes.
Okay. How about the rest of the complaints?
September 2000 complaint, it was sent to Carlton Enterprises, Inc., which was the license name at that time, to an address in Lenoir City, 2110 Town Creek Road, East, Lenoir City, Tennessee, 37772.
These complaints were sent to the addresses associated at the time with the license number and name associated. And for all of them was Mr. John Carlton listed as the owner or part owner. Now, one more thing. This complaint, this present complaint, apparently was opened in October of 2007. When did Mr. Carlton change again the name to Destiny Homes?
November 2nd, 2007.
After this complaint was opened?
Yes.
Thank you. I have nothing further.
Board members have additional questions for the witness?
Carolyn, Mr. Carlton Johnny stated that Car Development was actually Mike Carlton and Mr. Carlisle. However, on your documentation, if I'm correct, your documentation says it was Mike Carlton and Johnny Carlton as owners of Car. Am I correct?
Yes.
Who does it say who filled that application out or signed? Was it signed by Mr. Johnny Carlton or Mr. Mike Carlton?
Both.
Okay, thank you.
Was April 7th, 2003. The Destiny was in 2007, November 2nd, 2007.
Carlton Enterprises was changed to Car. And
From John L. Carlton to Car Development that time. But from Car Development to Carlton Homes, Inc. And this was September 2006. And this no longer had Mike Carlton on it, but it did have John Carlton, Brad Carlton, and Chip Carlton. The original app for that was turned in did have Andrew Carlton, Chip Carlton, Brad Carlton, and Gary Carlton.
Owner of the company?
His first application that he supplied for a mode change to go from Car Development did list Gary Carlton on there. He was written, and he said the response was the mistake with regards to marking yes when they ask about new owners. It says that it should have been marked no. This was done in error, as there has been no change in the names of the officers. They are still the same as shown on application. And he signed this on September 8, 2006, and sent in a revised application to remove Gary Carlton.
Gary Carlton was removed as an officer.
Yes.
Okay.
2008, is that what you said when it got removed?
2006. This let's see. This one was some. Let's see. And the one with Gary's name was June 30th, 2006, and then this the revised one was September 2006.
So as of September 2006, Gary Carlton was not an officer.
Right, because it was never approved. It was a request. It was actually a request for a name change.
And
since
then this complaint that we're considering came in 2007,
yes,
and the affidavit signed by John Carlton on October of 2007 says specifically that Mike Carlton or Gary Carlton are not agents, employees of Carlton Homes Incorporated.
It seems there's no additional questions to the witness. Is that correct?
Yes, ma'am.
Thank you for your rebuttal testimony. Mr. Carlton, did you wish to give any rebuttal testimony?
Yes.
If you would, please take the witness chair after the previous witness has removed herself from it.
I would just like to say that things were so going on behind my back that I was unaware of, because never would I put Gary as an agent on a form for my contractor's license. And truthfully, nor Mike. they are two brothers that I've been involved with, and sometimes you just don't see eye to eye. And, I just want the board to know that I've been doing this for a long time, and I would never, ever jeopardize, at least knowingly, my license, because that's what I've chosen as my life. If I don't have my license, then I technically don't have a job. So, and I just want you to know that I've been completely honest to the best of my ability, and I've never given Gary permission to pull my license, and he has never pulled a license. He has used my license number without my permission, and a lot of this documentation, just like what she just presented, I'm a very trusting soul, and a lot of this was done without my permission. A lot of this was done without me even knowing about it. So that's what I wanted to say.
Board members.
Ask Mr. Carlton, can you tell us your involvement in car development?
Okay, when I came from Knoxville, my brother had a company called Car Development, Mike Carlton. I was still a licensed contractor. They hired me out. I was just a contractor for Car. I built probably 6 or 8 houses for my brother Car and Dan Carlisle, which reminds me that my license, I'm not sure how that happened, but my license has never been in Car. My license has always either been in Carlton Homes or Destiny Homes.
What was the license number for Car?
I don't even think there was ever a license for Car that I know of. I mean, I don't know if there was a contractor's license for Car.
That apparently you signed and your brother signed?
That's a document that I haven't seen that I signed because I was working for Car. Dan Carlisle and my brother had created a partnership. Dan Carlisle worked for UPS or retired for UPS. I think he had some money. I came over here. Dan and Mike hired me as a contractor to build these houses. There was never a partnership.
The original license, in I think you said 1982, was it in Carlton Enterprise?
Yes.
And then in 1996, it changes to Car Development with the same license number 23761.
In 1996.
Well, it says 1996. Oh, I'm sorry, 2004, Car Development. Or 2003 for, so it goes from Carlton Enterprise to Car Development to Destiny's.
I never, as far as I know, I was never Car.
Mrs. Lazenby testified that this same license number was associated with Car. So our records are wrong?
Oh, I mean,
okay. Well,
is there something showing
when you did Car? Did you go pull the permits yourself for the 8 homes you did for them?
I went and pulled them under. I think at that time I was operating as Carlton Homes.
But you pulled them under your own license.
Yes.
For as a agent for Car.
Correct.
So they hired you to build the houses, but you built them with your own license number.
Correct.
Okay.
And unless I'm majorly confused, I never knew that my license number was ever licensed under Car.
And we see the documentation that says his license number was associated with Car.
Could she show the witness that paper first, and then us?
I haven't seen it either, yeah.
Okay.
If that would be all right. I think he needs to know what
Right, Ms.
happened to him.
Lazenby, if you could show it to Ms. Ryan first, and then to Mr. Carlton.
Now, is this a document showing that?
Right. Did you have a question about the document, Mr. Carlton, for Ms. Lazenby? Speak into the microphone, please.
I was
Mr. Carlton.
asking her how long it was in Car, and then it went back to Carlton Homes.
And if you,
Relevant anyway. That's, unless somebody objects, why don't we just leave the car stuff behind?
okay, so the board decided they don't want that, don't need that, rather.
I just wanted Mr. Carlton to see.
It's necessary if he
Oh, okay. that's fine.
testified. He's never been in business with Gary Carlton, but if our paperwork shows he was in business with Gary Carlton, and he's testified.
Well, Car wasn't Gary Carlton anyway.
No.
Carl was Mike Carlton and Dan Carlisle. It's maybe. I don't know. I don't know what that paper says.
It says that is it okay if I talk? You'll tell me if I do something wrong. It says it was, make sure I got all my papers right. It said it went from Car Development to Carlton Homes, Inc. And it had John Carlton, Chip Carlton, and Brad Carlton. And then it's got his notarized signature to first went to Car Development. It was John L. Carlton to Car Development, and it showed on the one that was approved was John Carlton and Mike Carlton. It has the notarized signature of both Mike Carlton and John Carlton. And that's for Car.
50/50 owners, or?
It doesn't list the ownership, it just lists Mike Carlton as president and John Carlton as vice president.
I mean, can I speak? I mean, I was never part of Car.
But your name's on that application.
It's on, but that's not my signature.
I think he is telling the truth.
There were some issues with my brother in Car. I'll leave it at that. With my other brother, Mike. But again, I in no way would ever intend to do anything illegal, and I think that's what this is all about. And no permits, again, I reiterate, no permits by my brother have ever been pulled. My permit number has been used, but he has never had permission and has never pulled any permits. And I think that's the big issue.
Question is, did you, and that's not the allegation. The allegation is that you entered an agreement with your brother, and your own sworn affidavit says, for the last 2 years, he agreed to pay my renewal fee if in return on occasion he could pull permits with my license number. You said, under testimony here today, that you agreed with him to do that, but only unless you and he had some form of agreement. So the allegation is here that we've been asked to find if there's a violation or not if he pulled one. Not even if you ever told him to go ahead and do it. The allegation is, in our causes of action that we've had put in front of us, that you entered into an agreement with him to let him do that. That you had a conversation with him and that you said, yeah, under certain circumstances you can do that. You signed an affidavit that says you did do that. And you haven't really denied that you did do that. All you've denied is that you ever gave him permission to go ahead and do it.
No, I denied that I did do that. I did not do that.
You did not have that conversation.
I did have the conversation, but it never got followed through on.
I didn't ask you if it got followed through on. Did you have the conversation?
I had the conversation.
Okay, yes or no, did you have that conversation?
Yes.
And the conversation was of the standard that you wrote here in this affidavit, that he agreed to pay my renewal fee if in return on occasion he could pull permits with my license number. And I understand your qualification that he was never to do it unless you agreed with him that you were going to work something together. Did you have that conversation with him? Yes or no?
Not in that way, no.
Did you have a conversation with him about using your license number to do jobs?
Yes.
Questions from the board members? Is that right? Opportunity for closing argument.
In a previous case in Blount County, Tennessee, of Davis versus Hobbs, a contractor's license was revoked by the state, by the court. What was the issue? Permission to pull permits for an unlicensed party. The trial court and the Court of Appeals found that to be a civil conspiracy and determined that that license should be revoked. I did not ask for revocation here, but it is obviously a serious matter to allow an unlicensed person to have permission to pull a permit. And that's the issue here today. Can we tell when Mr. Carlton is telling the truth? I don't know that you can tell. He denies affidavits that he had signed in front of a notary, mind you, always in front of a notary. So if the notary then perhaps lied or perhaps looked at a false license or something to confirm it, I'm not sure what he's suggesting there, but he's suggesting that somehow that's not his signature even though it's not in front of an affidavit, in front of a notary with an affidavit. He's also suggesting that somehow what he says in an affidavit in 2008 is not exactly what he meant or said, even though he said in that affidavit, we had an agreement, he could use my license to pull permits if he paid my renewal fees. The fact that it may or may not have occurred isn't relevant. We do know that his brother routinely, and that brought him into trouble, used that license number. Were there permits pulled? I don't know. Again, it's not relevant. What's relevant is this man thinks it's okay somehow in certain circumstances to allow his license to be used to pull permits. We heard from Carolyn about the reason we have license laws in the first place. It is to protect the public. It is to protect the public against such unscrupulous persons as perhaps his brother is. We have a man who doesn't know how to tell the truth. I don't think. He allows his brother in one hand to pull permits. He says, maybe, if I could do it, if I can. It doesn't matter. Either it's against the law or it's not. And if it's against the law, I suggest that he needs to be civilly punished. We are asking that he be required to pay civil penalties in accordance with your laws, that he be required to pay all the court costs involved in this matter, including those of the investigation, and that I wish you had some education to educate this man about what is the truth and what is not, but apparently you don't. But that you seriously consider the serious nature of this allegation and Mr. Carlton's blithe and answers to the questions asked today in assessing your penalties. Thank you.
Let me ask the board chair, did you want me to charge the board at this time and then go into deliberations, or did you want to take a 10-minute break before the charge? Okay, that's
I
fine.
do have proposed findings of facts and conclusions.
Oh, you do
of law.
have
I
proposed findings of fact. All right, the state has proposed findings of fact and conclusions of law that the state is having distributed to you at this time. I'll give you a minute to look at that before the charge. All right. You've just heard the proof in the matter of Commerce and Insurance versus John Carlton doing business as Carlton Homes, Inc., and also doing business as Destiny Enterprises, LLC. In the Carlton matter, the state is seeking that the respondent be disciplined for allegedly violating Tennessee Code Annotated 62-6-101 et sec., particularly Section 62-6-118A1, whenever any person, firm, or corporation claims to have been damaged or injured by the gross negligence, incompetency, fraud, dishonest dealing, and or misconduct in the practice of contracting on the part of any person, firm, or corporation licensed hereunder, files suit upon such claim in any of the courts of record of the state and recovers judgment thereon, such court may, as a part of its decree or judgment in the case, revoke the certificate of license under which the contractor is operating at the time of the aforementioned wrongdoing. Subsection D gives the board the power to revoke or suspend any license or renewal granted by it for any of the reasons stated in this section, or for a failure to observe the terms and conditions of any license or renewal granted under the provisions of this chapter, or any bylaws, rules, or regulations adopted or promulgated by it as provided in Section 62-6-108, or for a violation of the terms of any license. Subsection E permits the board to impose a civil penalty not to exceed $5,000 per offense against any person or firm who violates the terms and conditions of an existing license to engage in contracting, or against any person or firm who engages in unlicensed contracting. Subsection H permits the board to refuse to issue or renew a license to any person, firm, or corporation for lack of financial stability, lack of expertise, submission of false evidence with regard to application of license or renewal, conviction of a felony, and any other conduct which constitutes improper, fraudulent, or dishonest dealing or violation of the statute. Pursuant to TCA 56-1-308 of 2008 and Rule 680-1-.193, each day of continued violation constitutes a separate violation. The state has proposed a civil penalty in the amount of $5,000 for the alleged violations pursuant to TCA 62-6-118E. TCA 56-311A and Rule 780-5-11-.011 also permit the board to assess the respondent the actual and reasonable costs of investigating and prosecuting this matter. As sole and exclusive finder of the facts in this matter, you must conduct open deliberations and make findings of fact and reach conclusions of law based on the facts found, determine the penalty, if appropriate, and determine policy reasons for your decision. You must make findings of fact based solely upon the evidence presented to you in this hearing. This evidence includes the testimony of witnesses and any exhibits introduced. The notice of hearing filed by the state is not evidence but may be used as a guide to assist you in making your findings, as well as the proposed findings of fact that the state has provided you, but it's the sole responsibility of the board to make its own facts in this matter. The attorney representing the state has argued her respective theory of this matter. The statements of counsel are not evidence but are merely arguments to persuade you to see the evidence in the light most favorable to their particular position. Give such arguments whatever, if any, consideration you feel is appropriate. In making your findings, the board must determine the credibility and weight to be given to the evidence presented by each witness. If there's conflict in the testimony between witnesses, it is the responsibility of the board to reconcile those conflicts if possible. But if it is impossible to reconcile the conflicts between witnesses, the board must make the determination as to which witnesses to give the most credibility. In reaching such a determination, the board should bear in mind the following principles of law. The law presumes that all witnesses who are sworn to the oath testify to the truth. It is the obligation of the finder of fact to attempt to reconcile any discrepancies in the testimony between witnesses, but if this is impossible, then it's necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite his or her oath. In determining which witness is believable, the board members as fact finders have wide discretion. However, the board members should consider in determining the truth the witness's interest, if any, in the outcome of the matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts about which they are testifying, and their conduct and demeanor on the witness stand. Before the board should consider any possible disciplinary action, the board must first determine whether the state, the petitioning party in the Carlton matter, has met its burden of proving the charges that it has brought by a preponderance of the evidence. If the board finds it helpful, it may weigh the evidence mentally on the scales of justice. If the scales tip in favor of the state, the board must find for the state. If the scales tip in favor of the respondent, the board must find for the respondent. If the scales are evenly balanced, the board should bear in mind that the state has the burden of proving the charges. The respondent does not have the burden of proving that he is innocent. If, after a full and impartial review of the evidence presented to you, the board feels that the state of Tennessee has carried its burden of proof by a preponderance of the evidence, the board must then, based on the findings of fact, determine whether the conduct of the respondent is such that he is guilty of either one, any, or all of the charges. If the board finds the respondent guilty of a charge or charges, then the board may take appropriate disciplinary action. If, after a full and impartial review of the evidence presented to you, the board may find, for example, that the respondent has not violated the Contractors Licensing Act and its of 1994 and its accompanying regulations, or the board may find that the respondent has violated the act and that discipline of the license and or imposition of a civil penalty is warranted. And in fact, the board may find that the respondent should pay the cost of the proceeding in addition. In assessing the alleged violations and appropriate penalties, if applicable, the board may consider any evidence that the parties have introduced, including but not limited to whether the conduct was or is of a continuing nature versus a one-time occurrence, whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, the interests of the public, the willfulness of the violation, and the extent to which the violator has sought to compensate any victim or victims of the violation. Additionally, the board may consider what it has done in previous similar matters for comparison purposes. I mention these examples of possible discipline for illustration only and not in any effort to sway the board in its determination. From time to time, I may have been called upon to make rulings of law and procedure during this hearing. The board alone must make the decision regarding the merits in this matter and must not draw inferences concerning any opinion that I might have in this matter from any statement or ruling that I have made. Chairperson Brew Abroad, please proceed with the deliberative process, establishing findings of fact, conclusions of law, and policy reasons for your action.
Okay.
Well, my last questions to Mr. Carlton, I think, get to the meat of it. He's not being charged with allowing it to happen. He's not being charged with even knowing that it happened. He is charged, and I think the charge is well drawn by our counsel, by the state, with agreeing, entering in what I termed at one point a conspiracy with his brother to, in this point 2 in the findings of fact that we have before us, he made that agreement with his brother to allow this to happen. And we've read it several times in this June 8th, June 3rd statement. He agreed to pay my renewal fee if in return on occasion he could pull permits with my license number. He wrote this in his own handwriting, went in front of a notary. The notary has initialed it, the statement himself. It's clear that the notary read it aloud to him, said, "Is this your statement?" He swore to it. He signed it. It was notarized. He admitted on the stand. He had the conversation. So the charge is, did he enter that agreement, which is an agreement to do an illegal thing? For all the talk, he admitted that he had the conversation. So I don't think there's any question in the finding of fact that he committed the violation. I don't think that we were wondering a little bit why weren't any of these other cases brought to us with him. I don't think there's any evidence that I've heard that he actually allowed it to happen. Maybe he didn't even know it. I do find it peculiar that he testified for the defense of his brother in that criminal case when supposedly he's a victim. His good name's been sullied by this unlicensed activity and illegal use of his license number that he didn't authorize. Yet he enters in as a defense witness in the trial. But that's his credibility is in other areas questioned, but it doesn't really matter. The charge is, did he enter into the agreement, an illegal agreement, a conspiracy with his brother to violate the law? Whether it was followed through on, if you conspire to rob a bank, it's a crime, whether you wind up going down to the corner with a gun or not. And I think that his own admission, his own testimony, his own affidavit makes it clear that that's exactly what he did. So I think that the findings of fact and the conclusion of law, because it would be at least improper, it says improper or dishonest dealing in conclusion of law, I think they're both well-founded and well-drawn, and they don't go too far. I think if we tried to say he allowed it to happen, it would have gone too far, because there's no evidence of that. We may have questions in our own mind, but there's no evidence of it. But there is evidence, his own testimony, his own affidavit, his own admission on the witness stand today, that he did have the conversation and enter into that agreement.
Everyone agree with those findings of fact and conclusions of law, or anybody else have anything they
I'll
wanna
move
add?
that we adopt the findings of fact and conclusions of law.
Discussion? All right, all in favor?
Aye.
Any opposed? Fact and the conclusions of law have been agreed upon.
Penalty, such as suspension or revocation, that you would add, or would you not add?
I think we've talked about the penalty yet.
Question
That
is,
discussion now.
question is how serious? Man talked to his brother, said, "You bring me a deal, we'll work out a deal and we can build these houses." That's the question. The only problem I have is in his statement that he signed, he could pull the permits. Well, okay, he wrote that maybe with an investigator standing over top of him. I understand a lot of times we all make mistakes as we write stuff down. We're not, as he said, he wasn't aware how serious it was, or could be. So, probably sitting on the front porch at the house or wherever, in the office, and he said, "You know, man, I think I might have a couple of deals for us. We'll bring them on and we'll work out a deal. But you can't do it unless I say you can." That's the way I took another sentence in that agreement. Unless I know about it. So, how serious is it?
Well, the seriousness is the brother apparently, and this is speculation, took it as a tacit approval for him to go ahead and do exactly.
Has the public been injured financially?
By this case?
That's all we can talk about. That's all we should talk about is this one sign.
By his brother, probably, but not by John.
By this licensee, has the public been financially injured?
By his agreement with his brother, did that lead to this case that we're hearing before, him acting without a license? Well, that's a good question.
It's great. It's great that we're here to protect the public. I think Mr. Carlton, a lot of folks in our industry, he was blowing and going pretty good. Brother came in. I can't believe he would do that for, I think it's $250 to renew. Is that what it is? I mean, a couple of $100 if it was for that money. That's big money.
State attorney is proposing $5,000
$5,000
civil
fine.
penalty, and I think that's what we should ask for, because we could revoke the license. I mean, she cited a case in Blount County that states that due to the exact same thing, they revoked a license. No, it's not on the table, but we have that option.
That guy might have hurt the public too in Blount County. But
We don't know the circumstance, and it's an option, and we're not going to go that route. But I think the civil penalty of $5,000 that's been requested by our state attorney is reasonable. Plus court costs. It's very reasonable. Compared to what I make a motion that we assess a civil penalty of $5,000 plus court costs to Carlton Homes or Destiny Homes and John Carlton.
This is appropriate. I sure wish this could have been, I anticipate this could have been settled long before getting here. And it's a loser if they get 5,000 because it costs much more than that.
I agree with Reese. We've had these come up before, but we've had a lot of these that come up, and we've settled them on our residential.
Yeah, but they
Several
have to
we
agree
have
to
assessed
settle.
5,000, several.
Yeah,
This is
have
not
to agree
anything
to pay
unusual.
for it.
Settled it
Yeah.
without getting-
And settled it without getting
Yeah,
to this point.
exactly.
But
And
we're
so
at this point,
Yeah.
it is what it is.
Yeah, I agree with what you're saying.
All in favor of the motion, say aye.
Aye.
Aye. Opposed?
Aye.
Aye.
We ought to do a roll call.
Barney Tickle,
Aye.
Bill Mason,
Yes?
Keith Whittington,
Nay.
Reese Smith,
Yes.
and Cindy DeBusk, and Mark Brudd.
Yes. Two. Okay. Motion.
The policy reason for your decision.
Policy statement or reason for our conclusion. Policy reason is you can't offer to let an unlicensed contractor use your license.
Policy statement.
Second.
Any other discussion?
Aye.
Aye.
Opposed? Motion carried.
State will draw the order. This hearing is concluded. Thank you.
Kidding me. I've done nothing.
All right, did the
tried to settle.
board members wish a break
They
before we
tried to
go into
settle.
the next
Yeah.
hearing?
Yeah, yeah.
And we'll take a 10-minute break before we start the next hearing.
And I thought you were my friends, not my foe. I don't get it.
Owe $5,000 in civil penalty.
You're licensed, you're properly licensed today.
Do business.
Permit.
Not out of business.
Paid penalty.
Remains Wednesday, July 31st, 2013. This hearing is being held in Nashville, Tennessee. Concerns the matter of Respondent Gregory D. Baker, Tennessee license number 6408, docket number 12.14-120548A. My name is Madeline Williams. I've been assigned by the Secretary of State to serve at this hearing as administrative judge. This hearing is being conducted by the Tennessee Board for Licensing Contractors. Today's board is chaired by Mr. Mark Brudd. Assistant General Counsel Jesse Joseph represents the state in this matter. Gregory D. Baker is not present today. Mr. Baker, just making sure that he remains not present today. let me ask the state, what evidence, if any, does the state have that Mr. Baker was notified of today's hearing?
Your Honor, we have it. On June 28th. We also filed a motion relative to the sufficiency of our service of process in late June, and received an order from the court to the effect that the service was sufficient, but we do intend to put on proof to that effect, and we have an affidavit of our investigator Dan Kelly as proposed exhibit number 3, which sets forth his efforts to attempt to personally serve the respondent.
Please bring proposed exhibits 1, 2, and 3 forward at this time.
Sure.
All right, great. All right. The track and confirm is admitted at this time as Exhibit 1. Exhibit 2, the front of the envelope with Mr. Baker's name marked through. And then the affidavit of Dan Kelly is entered as Exhibit 3 in the matter. I find that the state made a sufficient and reasonable effort to reach Mr. Baker. Therefore, does the board wish to go ahead and go forward with the hearing today in the absence of Mr. Baker?
Yes, Judge.
All righty. Then I will make rulings regarding the order of proceedings, admissibility of evidence, and questions of law under the authority granted me by the Tennessee Administrative Procedures Act, but will not participate in the findings of fact or ultimate decision of this board. Those decisions will be made by the board members. I would ask the board members to identify themselves for the record at this time, starting with the gentleman to my immediate right.
Bonnie Tickle, Memphis.
Bill Mason, Greenbrier.
Keith Whittington, Johnson City.
Mark Brudd, Knoxville.
Reese Smith, Franklin.
Cindy DeBus, Knoxville.
Thank you. There's a quorum present of the board. Members of the board are reminded that during the time this hearing is being conducted, no discussion of this case should take place between board members, witnesses, attorneys, or other persons unless all parties are present. This board sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires that all board discussions and deliberations be in public before all parties. Failure to observe the Sunshine Law may result in the board's action being reversed or remanded if appealed. Board members, you should not draw any conclusions until all of the proof has been submitted. Please listen to all of the proof with an open mind. I would ask the state to distribute the notice of hearing at this time, please. I would invite the board members to take a few minutes to examine the notice of hearing so that you can determine whether or not you have any conflict with serving, whether or not you've received information, written, verbal, or otherwise, from any of the parties concerning this case. Is there anyone who has any conflict or potential conflict to disclose? During the course of this hearing, there'll be an opportunity for each of you to question each witness that testifies under oath. You should limit your questions to those that will develop evidence relevant to the factual allegations in the notice of hearing. Relevant evidence is defined as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Please limit your questions to those that are relevant to the factual allegations in the notice of hearing. However, you must reserve any portion of you must reserve any expression of opinion you may have to that portion of the hearing that's set aside for the board's deliberations after all the proof has been heard. The record in the Gregory D. Baker matter includes the following: April 24th, 2013, the notice of hearing. May 6, 2013, my opening letter. June 28th, 2013, the state's notice of service of documents. July 23rd, 2013, state's motion to deem service of notice complete and sufficient. July 24th, 2013, state's witness and exhibit list. July 26, 2013, order, service deemed sufficient. Mr. Joseph, are you aware of any other documents that should be a part of the pre-hearing technical record? All right. Then I will enter these documents as a technical record to date. At this time, I'm going to swear in those witnesses who are going to testify. Three people are being sworn. Do you swear or affirm that the testimony that you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that three persons were sworn. Any preliminary motions?
We simply asked, if it has not already been dealt with, that the respondent be declared in default, Your Honor, pursuant to TCA 45309 for his failure to appear or to defend.
Yes, the respondent is held in default, and the board has elected to proceed with the hearing in his absence.
Thank you.
Opportunity for opening statement.
Thank you, Your Honor. Good morning, members of the board. My name is Jesse D. Joseph, Assistant General Counsel in the litigation section for the regulatory boards. As the board is aware, we are here today on a notice of hearing and charges against the respondent, Gregory D. Baker, for engaging in the business of a home improvement contractor in Tennessee in the name of Junebug Construction, which is a name that the respondent was not licensed in, and also for installing a concrete patio at the home of complainants Tony and Terry Moorby in a grossly negligent manner, evidencing far more than mere incompetence. The state's proof will show that the respondent, Gregory D. Baker, was originally licensed as a home improvement contractor in 2010 in his own name, and that his license expired on February 29, 2012. The proof will also show that the respondent entered into a contract in the name of Junebug Construction with Tony Moorby to pour this concrete and install this patio at their residence at 9190 Brushboro Road in Brentwood, Tennessee, on or around May 6 of 2011. The proof will also show that the respondent finished this job on May 9, 2011, according to the complaint of the Moorbys. The proof will show further that the respondent charged the Moorbys $3,450 per the contract, but that they paid him a total of $3,750, and that the respondent provided to the Moorbys a business card of Junebug Construction referring to himself as the owner. Finally, the state's proof will show that after the complaint against the respondent submitted by the Moorbys was opened, an inspection of the respondent's work was conducted in October of 2011 by one of the state's contractor inspections for the Division of Regulatory Boards, Donald McCormick, who found in his inspection report that the respondent had engaged in poor workmanship and gross negligence as to this job due to items found such as severe spalling along expansion joints throughout the slab, patio sloping in certain areas back toward the home, failure to install sufficient drain holes in the retaining wall to permit runoff into the backyard, a lack of a wall or a concrete buildup around the vent holes at the back door, which left a large hole with nothing to prevent water from running into the crawl space vent. Further, the respondent failed to stain the concrete properly. At the conclusion of all the proof and based upon this respondent's failure to cooperate not only with the state but also with this board in this matter by failing to appear and participate, the state believes that it will have proven by at least a preponderance of the credible evidence that the respondent has violated, first of all, Tennessee Code Annotated 626509A3, which states that this board may discipline a licensee who lacks competence as evidenced by work performed in a poor and unworkmanlike manner or when the work is inadequate, and also that he's violated Tennessee Code Annotated 626510-8, which states that it is a prohibited act for a licensee to conduct a home improvement business in any name other than the one in which the contractor is licensed. We believe that the proof will show that the respondent did both of these things, and that the board should enter a final order assessing a $500 civil penalty for each of these two violations, at least for a total civil penalty of $1,000, pursuant to 626509B, which grants the board the ability to assess a civil penalty not more than $500 for certain violations of the Practice Act, and that the board, based upon the violations proven, as well as the respondent's refusal to cooperate and to appear in defense of this matter, that the board refuse to issue the respondent a new license, and that the board include within its order an assessment of the cost of the Administrative Procedures Division that employs our administrative law judges, the cost of the court reporter, and the cost of the investigative section of the Division of Regulatory Boards. Thank you. Before I call my first witness, can I distribute to the board exhibits numbers 1 through 3, which I already have copied for them so that they can have this for the record? The state would call as its first witness Dan Kelly. Please state your full name for the record, sir.
Danny Kelly,
And what is your business address, Mr. Kelly?
500 James Robertson Parkway in Nashville, Tennessee.
And you are an employee of the Tennessee Department of Commerce and Insurance's investigative section, correct?
Yes, sir, I am.
And what is your title, sir?
I'm a regulatory board investigator.
And how long have you served in that capacity?
About 14 years.
What are your general duties as an investigator for the Division of Regulatory Boards?
I work for the state attorneys for the various boards on fact-finding on cases that are presented by the staff attorneys.
Are you familiar, Mr. Kelly, with the complaint in this matter which we are addressing today?
Case I've handled, yes, sir.
And how are you familiar with this complaint against Gregory D. Baker?
I received investigative request from your office, from you, to locate Mr. Baker and get a current address on him, and also to serve him with the notice of hearing and charges.
Approximately when did you receive this assignment, sir?
Would have been in June of this year.
Did you succeed in personally serving him with a copy of the notice of hearing and charges which was filed in this case?
Did not have a chance to serve him personally, no, sir.
And have you prepared for my office an affidavit which details your efforts in this regard?
Sir, I did.
Copy of the document which I'm showing you now, which has already been marked and entered into evidence as Exhibit B, a copy of your affidavit that you prepared in this matter?
Yes, sir, it is.
And is that affidavit that's to your knowledge, information, and belief?
Yes, sir.
Looking at your affidavit, Mr. Kelly, which is Exhibit number 3, tell us what the attachment to the back of your affidavit, Attachment A, represents.
This is a real estate assessment data. After I received your request to locate Mr. Baker, I have two tools that I use to locate and confirm his address. We had an address of 9119 Berry Bell Lane in Bon Aqua, and what I've used is the real estate assessment data, which shows that that particular residence is owned by Mr. Gregory Baker. And as proof, I submitted that with my case report.
After you researched the ownership of this property at 9119 Betty Bell Lane in Bon Aqua from the State Controller of Treasury's Real Estate Assessment Database, what did you do next in order to try to locate this respondent?
To further confirm the information that was received, I ordered and received a National Comprehensive Report on Mr. Baker.
What is a National Comprehensive Report?
It's an information system that's made available to us. It'll have the individual's name and all pertinent information that they have, such as vehicles owned, addresses, type of licenses held, even the utilities, if they have their name on utility services and all that. So it's just a comprehensive report on a subject that we use for investigations.
What did the National Comprehensive Report as to this respondent show?
It shows that he had a state of Tennessee driver's license. The driver's license was issued to him at the address 9119 Berry Bell Lane in Bon Aqua. It also shows that the residence at 9119 Betty Bell Lane had utilities turned on in the name of Mr. Gregory Baker.
What did you do next?
Located the telephone number to contact Mr. Baker, and I made telephone contact with him, explained who I was, and I tried to arrange a meeting with him so I could issue him the notice of hearing and charges.
And what were you told?
Mr. Baker understood what I wanted, and he said that this incident occurred well over 2 years ago. He's no longer going to be doing any type of contracting work, and refused to meet with me. He says he's not interested in anything that I or the state have to say.
How did that conversation end?
He hung up the phone on me.
And what did you do next?
Well, to confirm, the next day on June 5th, I went to the address of 9119 Betty Lane to see if I can talk to him person to person and serve him with the papers. There was no answer at the door. And as a matter of policy, I normally check with neighbors. Went across the street, spoke to the individual that was out there, and he confirmed that Mr. Baker lives at that residence along with his daughter and son-in-law.
Leave any documentation at Mr. Baker's front door?
Yes, sir. I left my business card with a note on the back of the business card requesting that he contact me.
Mr. Baker return any of your calls?
No, sir, he hasn't.
And what did you do next?
It was apparent at that point that he was going to be uncooperative and unwilling to meet with me, so I concluded my case and turned it into the state.
No further questions of this witness at this time, Your Honor.
Thank you for your testimony, sir. Your next witness.
Your Honor, the state would call as its next witness the board's executive director, Carolyn Lazenby. Would you please state your full name for the record, ma'am?
Carolyn Lazenby,
And what is your business address, Miss Lazenby?
500 James Robertson Parkway,
And you are, I'm sorry, go ahead.
in Nashville.
Are you an employee of the Tennessee Department of Commerce and Insurance?
Yes.
And what is your title, ma'am?
Executive Director,
And how long have you acted as executive director for this board?
8 years.
And what are your general duties as executive director, Ms. Lazenby?
Oversee the daily operations of the licensing board for the license programs, which include contractors, home improvement, electricians, and plumbers. And also this includes accepting new applications, renewals, and complaints as well.
Are you the official custodian of the board's records?
Yes.
Are you familiar with the respondent in this case, Gregory D. Baker?
Yes.
And how are you familiar with him, ma'am?
The board received a complaint against Mr. Baker on September 9th, 2011.
Is the respondent, Gregory Baker, a licensed home improvement contractor by this board?
He is no longer a licensed home improvement contractor.
When was he first licensed?
February 25th, 2010.
And when did his license expire?
February 29th, 2012.
What is his license number?
6408.
And what was the name the license was issued in?
Gregory D. Baker.
Now, according to your books and records, ma'am, what is the last known address for the respondent?
9119 Betty Bell Lane, Bon Aqua.
What is the zip code?
37025.
You just mentioned a moment ago a complaint that was filed against the respondent that was transferred to your office from the Division of Consumer Affairs by Tony and Terry Moorby, correct?
Yes.
Copy of the document which I'm showing you now, a copy of that complaint.
Yes.
You maintain a true and correct copy of it within your official books and records for this respondent?
Yes.
Do you have a business duty to do so?
Yes.
Your Honor, we would ask that the May 2011 complaint of Tony and Terry Moorby against the respondent, which is pre-marked as Exhibit Number 4, be entered into evidence. All right, Ms. Lazenby, in addition to this complaint against the respondent, which has been entered into evidence as Exhibit Number 4. Did the complainants in this matter, Tony and Terry Moorby, submit any additional documentation to your office?
Yes.
And what else did they send your office? Or what else was your office provided?
Provided pictures of the complaint.
You provided with a copy of the signed contract by the respondent?
Yes.
Were you provided with a copy of the checks that the complainants paid for this job?
Yes.
Were you provided with a copy of the respondent's business card?
Yes.
Asking that you look at the document which my co-counsel is presenting to you now and tell me whether or not you can identify that document.
Yes.
And what is that document?
It's a copy of a contract in the name of Junebug Construction. It says owner Greg Baker with the license ID number 6408.
And for what job is that contract relating to?
Pouring of concrete at 9190 Brushboro Drive in Brentwood for Tony Morby.
What is the date of that contract?
May 6, 2011.
That contract signed by the contractor as Greg Baker?
Yes, it appears so.
Do you maintain a true and correct copy of this document within your official files relating to this complaint?
Yes.
And do you have a business duty to do so?
Yes.
Your Honor, we ask that the May 6, 2011 contract signed by Gregory Baker for the performance of this job for the Moorbys at 9190 Brushboro Drive in Brentwood, dated May 6, 2011, be entered into evidence as Exhibit Number 5. Thank you. You also mentioned, did you not, Ms. Lazenby, that the complainant supplied your office with copies of the checks that they issued to the respondent totaling $3,750 for this concrete patio job, as well as a copy of the respondent's business card in the name of Junebug Construction, that you received those documents?
Yes.
Copy of this next proposed exhibit, which I'm showing you marked for identification as proposed Exhibit Number 6, text that they wrote to the respondent and his business card?
Yes.
And do you maintain true and correct copies of these documents within?
Yes.
And do you have a business duty to do so?
Yes.
Your Honor, we ask that the two checks dated Ms. Lazenby, according to the business card which is located on the bottom of Collective Exhibit 6. Does this respondent have any limited plumber's license issued by this board?
No.
Does he have a limited license as an electrician issued by this board?
No.
Has this board ever issued a contractor's or a home improvement contractor's license to an entity named Junebug Construction?
No.
Did your office ever grant the respondent any authority whatsoever, ma'am, to conduct home improvement contractor business in the name of Junebug Construction?
No.
Did you receive any response from the respondent to the opening of this complaint?
No.
No further questions of Ms. Lazenby at this point, Your Honor.
Any other kind of license through the state that you know of?
Is it listed?
It's listed as Gregory D. Baker. Only, and that's also how this was on his bond.
Thank you, Your Honor. As the state's next witness, the state would call Donald McCormick. Morning.
Morning.
Could you please state your full name for the record, sir?
Donald E. McCormick,
And Mr. McCormick, what is your business address?
500 James Robertson Parkway, Nashville, Tennessee.
And what is your title, sir?
Contractor inspector.
Are you an employee of the Tennessee Department of Commerce and Insurance?
Yes.
Of the Regulatory Board section?
Yes.
How long have you been a contractor inspector for Regulatory Board, sir?
7 years.
What are your general job duties as a contractor inspector for the Department's Division of Regulatory Boards?
I visit job sites to ensure that contractors are properly licensed per the work they're doing, and from time to time I also get inspection requests from the legal office for the board when a complainant has a problem with some construction that's been performed on their property or a new home.
How many construction sites, sir, have you inspected in Tennessee in that capacity?
Between 300 to 350.
How many of these have been residential construction sites?
Probably 95%.
And how many of these inspections which you have done have been for concrete work?
Oh, probably 20%.
Do you have a high school diploma?
Yes.
Do you have any education or training beyond high school in the field of contracting and codes enforcement?
Yes, I have. Get my notes here. I have taken the National Certified Inspectors Training, the NCIT. What that is, it's training for all investigators and inspectors to help you understand exactly what you're looking at, what type of pictures to take, what type of documentation I should keep in case I have to go in front of a hearing. It also teaches me what to say and what not to say. I also am a member of the Middle Tennessee Code Officials Association. What that is, all building officials here in Tennessee have to attend continuous education. I do attend that. The reasons I attend is I get updated on the new technologies, the new construction practices. I also get to make connections with building inspectors, help them answer questions, things such as that.
All right. And you've done a lot more than that, have you not?
I have.
Have you put together a curriculum vitae for my office, Mr. McCormick, which lists your current work experience, your training, and your certifications in the fields of contracting and codes enforcement?
Yes.
Right.
Yes.
And is this curriculum vitae correct and current to the best of your knowledge, information, and belief?
Yes.
And did you put this together?
I did.
And did you provide this to my office?
Yes.
Your Honor, we ask that the current curriculum vitae of Donald McCormick be entered into evidence as the next numbered exhibit, exhibit number 7.
Document is entered at this time as exhibit number 7, and it may be distributed to the board members.
Okay, Mr. McCormick, let's turn to page 3 of your curriculum vitae. Tell us about the courses you take by the Middle Tennessee Code Officials Association in construction techniques.
When I attend these meetings, they usually have an engineer or another building official there. They go over the newest techniques in construction. We also go over any questions that a building inspector may have. We also get contacts for manufacturers, because a lot of times they have the directions on how to properly install their products to be within warranty.
Okay. As a member of the Middle Tennessee Code Officials Association, are you required to obtain this continuing education?
No.
Notwithstanding the fact that you're not required, how much do you obtain per year anyway?
Probably 3 to 5 hours monthly.
Okay. Explain to the board what is the significance of you having completed the National Certified Inspector Training Basic Program in 2010?
What that does, all the inspectors, we go to the same course to make sure our reports are identical. They basically just help us to have a better report, to know what questions to ask as we're doing our inspections.
Did you complete that program?
I did.
What does completion of that program entitle you to do?
It gives me a certificate, and it also counts towards any college credits if I choose to pursue some type of degree.
On the bottom of page 2 of your curriculum vitae, you state that you've completed the Home Inspector Pre-Licensing course, correct?
Correct.
What does that enable you to do?
When I first started in 2006, I've never been an inspector before, so I thought I needed some type of idea to know exactly what to look for. So I took the online course, and to give me a better understanding when I'm out on the sites to know what to look at, which was beneficial to me even to this day.
Let's turn to your work experience on page 2. Let's look at your work for Connors Concrete between 2003 and 2004. Do you know how to install a concrete patio?
Yes.
And how did you learn that?
When I worked with them for a year, I installed probably 20 to 25 concrete patios, porches, and driveways.
What was the nature of the finishing of concrete slabs that you did while at Connors Concrete?
Most of the finishing I did was by hand, either with a broom or with a trowel. We also did some etching as well.
And at the bottom of page 1 and the top of page 2 of your curriculum vitae, give us a summary of what you did while working for Homewood residents at Brookmont Terrace and for Lowe's Vanderbilt Plaza.
That property is 2 buildings, a 4-story building and a 3-story building. They house elderly people and also people with Alzheimer's. My responsibility was to ensure the safety of all the residents through the maintenance program. My responsibility was also to hire contractors and ensure they are doing their job properly to protect the assets of the company.
Now, as a contractor inspector for this department, Mr. McCormick, investigating complaints filed with this board, do you consider yourself competent to render an opinion on the quality of the respondent's workmanship regarding installation of a residential patio in a case like this?
Yes, I do.
Based on what?
Based on my professional experience.
Your Honor, based on this witness's education, training, and work experience, we would tender him to the board as an expert in the area of contractor inspections, concrete installation, and inspections of construction sites.
Mr. McCormick is deemed an expert.
Now, Mr. McCormick, are you familiar with the complaint we are here about today, the complaint filed by Tony and Terry Moorby against the respondent Gregory D. Baker?
Yes.
And what was your understanding of the complaint, sir?
They were unhappy with the construction of their patio. It was not level. It was incomplete. And the staining that was performed was not done correctly. And when it rained, there was not enough vents or enough drains to allow the water to properly escape.
And what was the address of this property?
It was located at 9190 Brushboro Drive, Brentwood, Tennessee.
And how did you become involved in this matter?
I received a request from legal to go out and take an inspection and see exactly what was going on.
And did you contact the complainants before you came out to inspect the patio?
I did.
Did you obtain their permission to come upon their property?
Yes, I did.
And when did you actually go out and perform this inspection, Mr. McCormick?
October 14th, 2011.
You prepare a written inspection report setting forth your findings and your opinions in this matter?
It.
Copy of the document which I'm showing you now for identification, a copy of your...
Yes.
Is it true and correct to the best of your knowledge, information, and belief?
Yes.
Did you sign this inspection report, sir?
Yes.
You maintain a true and correct copy of it within the official files of the regular...
I do.
Do you have a business duty to do so?
I do.
Your Honor, we ask that the two-page inspection report prepared by me.
Document is entered as Exhibit Number 8, and you may distribute it to the board members.
What was your overall impression of the respondent's work, Mr. McCormick?
Visually, it was very sloppy.
You take any photographs of the concrete patio installed by the respondent at the complainant's residence as part of your inspection in this matter?
I did.
The photographs that just showed you copies of the photograph you took of this patio,
Yes.
you maintain true and correct copies of these within the...
Yes.
Do you have a business duty to do so?
Yes.
We ask that the 2 pages of photographs, color photographs taken by the Inspector McCormick of the respondent's work on this patio be entered into evidence.
Document is entered into evidence as Collective Exhibit Number 9 at this time.
Let's look at the first page of your photos, Mr. McCormick. There are 3 photos on this page. The first page of exhibit number 9. Explain to the board your opinions of the respondent's work based upon the first page of these photos.
To me, it looks as if someone tried to put the expansion joints in with a butter knife. I'm sorry, it's very sloppy work. You can see the aggregate that's actually come up to the top of the joints.
You consider that competent work?
No.
Looking at exhibit number 8, your inspection report, you state that the respondent's work reflected gross negligence, correct?
Yes.
And what is the basis for that opinion?
I believe it went beyond incompetence into gross negligence because he installed 2 wells. The way the house is positioned, the crawl space is actually below grade. So when they installed the patio, he installed 2 wells. And what that does, that prevents water and also prevents people from tripping into these holes. He installed 2 of them, but the last one, which was next to the back door, he did not install. He just left it alone. That would have been okay if he would have put a berm or built up the concrete there. It's doing 2 things right now. 1, it allows water penetration, and 2, it's a major safety hazard. It's right next to the back door. If you come in there, and if you can tell from my pictures, you can fall in there. And it is big enough for a size 10 to 12 foot to go in there and it can hurt you.
Looking at the first page of exhibit 8, Mr. McCormick, why did you check no for incompetence?
I felt incompetence would have been if, in my opinion, he knew what he was doing when he failed to complete the job. He failed to install the wells before he poured his concrete. That's part of the framing. He should have put that in first. And as you can tell from the pictures, there was no intent to go back with the well. There was no, in my opinion, I'm not sure what they intended to do.
Consider this worse than incompetence?
Yes.
You also state that you noted the patio sloping in areas back toward the home, correct?
Yes.
And why is that a problem?
The way the concrete should have been poured, the water should run away from the home. It's no different than putting your backfill around the home. The concrete should have been sloped enough to allow the water penetration or the water to run away from the home. And in areas with just the eye, with not using a level, you could actually see where the concrete was flat and going back towards the home in spots.
Notice any spalling?
Yes, spalling or scaling. I did notice quite a bit of that.
Was that severe?
Yes, extremely.
And why is that a problem?
What scaling is, whenever you pour concrete, after you get it vibrated in, the bleed water will rise to the top. What that is, that's just excess water that allows the movement of the concrete to get out of the truck and get into the forms and get it vibrated so it can start going through its chemical process of setting up. Well, in my opinion, it looks as if it was poured, and then while the bleed water was still coming up, they started finishing. Now, what that does is that pushes the water back into the cement, okay? And when you push that water back into the cement, it dilutes the cement. The aggregate, which is the rocks, are very heavy, and they always sink to the bottom. To the top comes your cream, comes your cement. Whenever that bleed water, since it did not evaporate off in time, it mixed in with the upper layer of cement, and what that does, it makes it weak. And when it becomes weak, it becomes extra porous. Concrete is porous already, but it becomes extra porous, and it allows it just to break away from the aggregate. It will not stick to the aggregate because of that, over finishing.
What were your findings regarding the respondent's installation of drain holes in the retaining wall?
There was 2 drain holes, and obviously this area of the pad should have had at least 4. It was not raining when I was there, and the homeowner did not have any pictures, so I'm going off their word, and of course visually looking at it with the way it was not running away from the home in areas, it was obvious that the water would pool up in these areas. So really, it should have had more drains. It only had 2, and it was over a 10 by 10 patio.
What were your findings with respect to the respondent's installation of foundation vent wells?
Failure to install one of the vent.
What were your findings with respect to the respondent's staining of this concrete?
Because they finished the concrete when it was too wet, not properly, wasn't ready, that made it more porous. And the more porous areas grabbed a hold of that stain and sucked it in, so them were darker areas. The other areas, they were smooth, and the typical porous, which is the stain's made for, it gathered like it was supposed to. Therefore, you had lots of dark spots and a lot of light spots.
No further questions of this witness at this time, Your Honor.
Board members, questions for the witness?
Questions, Your Honor?
Is there such thing as a summary judgment?
Make a motion, Reese.
Accept the findings and the applicable statutes and the allegations of fact in regards to this case, the State of Tennessee versus Gregory D. Baker.
Okay.
Your Honor.
Those findings, and we do have them, but we would like to disseminate those findings.
The state to disseminate its proposed findings?
Yeah, we better look at them first, I guess.
Okay, if you would. Right, yes, you may return to your seat, sir.
We have a motion. Do we want to act on that motion, or are we?
Yes.
Do we have a second?
Second.
Any more discussion? Okay. All in favor, say aye.
Aye.
Any opposed? That motion carries.
Summary judgment as to the facts only, or does that include?
The conclusion law didn't Reese?
Oh, sure it did.
Yeah.
That include the proposed
Those judgment.
judgment?
Proposed judgment, I neglected to add the request that I made in opening to Statute gives you that authority. Refuse to issue.
And I guess it's not the right time to ask it, to notify other agencies in government that this guy has this kind of record of first of all, as far as that's concerned, is his refusal to cooperate, hang up on an inspector.
Motion that we accept the proposed judgment of $500 for the respondent's actions in conducting a home improvement business to Mr. Morby's job in the name of Junebug Construction, and $500 for his actions in performing work for the Morbys that was inadequate, poor, and unworkmanlike, and court cost, and refuse to issue a new license or a home improvement or a contractor's license in the name of Gregory D. Baker or any association Gregory D. Baker would have in a potential new license.
Have a second.
Second.
Any other discussion? All in favor of the motion, say aye.
Aye.
Any opposed? That motion carries. Take a shot at a policy reason for our decision.
Our statutes and to protect the safety and welfare of the public. Form of a motion.
Second.
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? The motion carries.
Yeah, I think we're
Before dark, anyway.